Bernard, Professor Dr. Hakan Karan, Professor Carmen Parra-Rodriguez, and Professor Dr. Shafullah Hadi will be the speakers. The floor is yours.
Ambassadors, distinguished delegates, distinguished professors, ladies and gentlemen. Welcome to this session. We are going to be discussing quite weighty measures today. As you are all aware, the issue of the delimitation of maritime zones, and especially the disputes over maritime zones, are one of the most contemporary issues at the moment. And in this session, you're going to lay the foundation for that, and in the next session, there will be practitioners giving their practical views on the subject. As you're all aware, we are running late, and I didn't want to make it long, so I had to discuss with my panel how much to leave out of their very distinguished bios. Okay, so I have before me 5 distinguished presenters, what I would call, for those of you who were at our conference in Boardroom in 2018, you might have been familiar with what we call the big guns. I have with me here 5 big guns today. Okay? So you better be very careful. Now, as I said, there's a long list, but I think I'll just deal with very brief issues. I'm going to start with my friend, my colleague at work, my friend, Rear Admiral Deniz Hukukundaki. The Rear Admiral is a retired 2-star admiral who has had a very long professional career at sea and on shore in both military and management positions in the Turkish Navy. The Rear Admiral obtained his master's degree in the area of the political science and political administration, which was reinforced by a degree in environmental studies, both from the University of Ankara. He holds an associate position from the Anatolian State University Department of Law. You have the floor.
Thank you, Professor. Adamiyodeke, ladies and gentlemen, good morning. It's again a privilege as always for me as well to address such a distinguished delegations from academia and the diplomatic services. And also, thank you for making this happen. Devkan and his chairman. Then, This morning, although we start late, I am going to address one of the contentious area, the differences in the preferred methods for delineation of the exclusive economic zone, continental shelf, and the territorial seas in the sense of equity versus adequacy. If you bear me 15 minutes, I have the feeling that at the end, you will become, most of you, entitled to represent your precious countries in such a harsh negotiations when it comes to the delimitation of maritime zones. So, maritime disputes are known to be the causing conflict if they persist in a prolonged period of time. Lord Curzon also made some statements about that. But unresolved boundaries may also chill economic activity, such as exploration work or fishing, because of fear of action by the other state. This is barely seen in the Eastern Mediterranean nowadays. Besides that, they may also inadvertently cause disputes if a fisherman is arrested for fishing in a border area or an oil discovery is made in an area of overlapping claims, for instance. Today, maritime boundary disputes exist on all continents. An updated overview provided that by the end of 2020, out of 460 possible maritime boundaries, only 280 have been agreed, and that the 180 outstanding maritime boundary disputes of approximately 39%. The aspirations where two or more states dispute on where to delineate maritime spaces, the water column, or the seabed or both. This includes disputes over the territorial sea, the exclusive economic zone, and the continental shelf. Against that background, we will be looking into just evolving legal principles. We outline that with its history, from abstract, tangible, and the practicality. As all you know, Article 33 of the UN Charter provides for the peaceful settlement of disputes by means of parties' own choice. States may choose several pathways for settlement. They may agree on mutual solution after bilateral negotiations. This is the orthodox way. But if negotiations are not successful, they may submit the case for adjudication at the ICOG or another international court, such as the International Tribunal for the Law of the Sea, ICOG. Or they may use third-party arbitration, such as the Permanent Court of Arbitration. If you look at the milestone in this business, we should look at equidistance first. In 1958, Territorial Sea Convention defines equidistance as the line at the point of which is equidistant from the nearest point of the baselines from which breadth of territorial sea of each two states is measured. Accordingly, the use of equidistance method was almost obligatory in the absence of an agreement, historical titles, or special circumstances. This was called Combined Equidistance Special Circumstances Rule, and generally respected the principle of equal division of the area of converging or overlapping claims. But that was also a time when there was no universally recognized territorial waters, limit beyond 3 nautical miles, nor any emergence of long distance criteria for exclusive economic zone or continental shelf based on sovereign rights. Apart from distance as the base of entitlement to both EEZ and continental shelf within 200 nautical miles, the privileged scope of equidistance was strongly objected by ICJ and dissenting judges. So the privileged status of equidistance method was diminished by the ICJ and arbitral tribunals, since it was considered as a method which in some cases may lead to inequitable and undesirable results. The demolishing and toning down equidistance went so far that the term equidistance and median line, which its brother, have disappeared from the text of Articles 74 and 83 in the 1982 Laws Convention. It remains only in the Article 15 of the 1980 Laws Convention on the territorial waters matter. Despite the law was diminished, equitism found its way into state practice up to 59% by some time in delineations on disputed maritime areas. Judges found it convenient to use the equidistance line as the starting point in the delimitation process. Naturally, in all cases, the decision maker looks at the line of equidistance as a point of departure, even if none of the parties has invoked it. That line will be eventually modified if it's found to produce inequitable results, as you know, otherwise that will impart to consent and could cause repercussions if persistent, impacting the goal of peaceful solutions. So that brings us to look at equitable principles. The notion of equity dates back to U.S. President's 1945 proclamation concerning the delimitation of continental shelf between the United States and adjacent states, in which he said the continental shelf boundary shall be determined by the United States and the state concerned in accordance with equitable principles. Truman's proclamation inspired the court during 1969 North Sea cases when the court stated that delimitation is to be effected by agreement in accordance with equitable principles and taking into account all relevant circumstances. This idea turned to be doctrine and was reiterated and confirmed by the ICJ and arbitral tribunals in subsequent cases. In the UNCLOS Articles 74 and 83, concerning the delimitation of the EEZ and coastal continental shelf provides for effecting the delimitation by agreement in accordance with international law and in order to achieve an equitable results. As you notice, this is almost verbatim from the court decision. Then how to achieve an equitable result? There is no straightforward answer to this question, but means to be employed should allow to reach that goal, and the end result must be equitable. Not only in the eyes of judges, but also in the mind of public opinion and those of litigators. The court's jurisprudence shows that equity is not a method of delimitation in disputes relating to maritime delimitation, but solely it's an aim that should be borne in mind in effecting delimitation. Also, one size fits all cases, and consequently, doesn't fit all cases, and consequently, the equitable principles had to be evaluated in the circumstances of the particular case, and all generalizations must be avoided. The ICJ and arbitral tribunals tried also several times to determine the concept of equity. During 1969 North Sea case, the court stated that it's not a question of applying equity simply as a matter of abstract justice, but of applying the rule of law. It was reiterated as such later during the 1985 Libya-Malta case. So equity is applied by the court as a part of international law and as a rule of law for the delimitation of continental shelf. There were cases when the court cited several equitable principles, such as principle of non-encroachments, the principle not to refashion the geography and not to seek to make equal what nature has made unequal. Even the use of those principles is not obligatory for courts and arbitral tribunals because of their highly valuable adaptability to each specific case. The use of those principles is also not obligatory for states. There is also no limit to the factors which states can take into account during the negotiation process on maritime boundary delimitation in order to achieve an equitable result. in view of the idea that there is a lack of normativity regarding the concept of equity, then how to one approach settling maritime disputes? It was progressively refined by judges. Tribunals have attempted to clarify the principles applicable to the maritime boundary limitation. On the other hand, majority of disputes at sea have been addressed and settled by engaging into bilateral negotiations between disputed parties or states. For instance, by the end of 2020, out of 460 possible maritime boundaries, 280 have been agreed, but solely 25 of them, or 9% of them, were settled through arbitration or adjudication, leaving the rest, 91%, to respective states' political engagements. So state practices seem to be most common still. In the spirit of UNCLOS, the 1982 agreement obliged that area of maritime delimitation, though seems to be intentionally left ambiguous, be first affected by agreement and be fulfilled in an imperative that any inequitable solution must be avoided. The equitable principles that govern delimitation vary due to the relevant circumstances of each particular case. Thus, concrete and well-explained justified relevant circumstances can lead to modification of abstract equitable principles. If all spatial relevant considerations and equitable principles considered together in a balanced way, that could help judges to establish resulting equitable principles. Nonetheless, there may be two significant approaches, reaching equitable results in principle. First, result-oriented equity approach, which rejects any obligatory method by stressing that any method corresponding uniqueness of cases in the view to reaching an equitable outcome could be used. If it helps arriving at an equitable result, then its equitableness constitutes useful. Also, the fact that equidistant method is not an obligatory principle of international law and that it doesn't enjoy any priority or preferential status. It was, in its Bangladesh versus Myanmar case, observed that issue of which method should be followed in drawing the maritime delimitation line should be considered in light of the circumstances of each case. Fundamental principle of maritime boundary delimitation is an equitable solution. The case law of maritime delimitation shows a constant recourse to ideas of equity or equitable principles and is been less favorable to the equidistance method. Second approach is named corrective equity approach. It uses a two-stage method. First, equidistant method is applied and later modified if relevant circumstances require it. The corrective equity approach follows the idea of the median equidistant line system as a rule, as I referred at the outset. In the second approach, maritime boundaries are often delimited along an equidistant line, every point of which is equidistant from the nearest points of the climate-based coastal baselines. Where coastal geography or other factors will render an equidistant boundary inequitable, then the boundary may diverge from equidistance. So, based on correct equity, we can look at principles and methods of delimitation in three stages. First, we will look at equidistance. Together with equity and equitable principle are to be observed. And second, we will look at drawing single maritime boundary. Third, relevant circumstances are to be solved. And fourth, proportionality checked. When proportionality is mentioned, it's about proportion of the area to be dedicated to one side and the coastal length of the side to be divided to each other. Other methods also to be examined. We have a list of relevant circumstances. It's a long, includes geographical and non-geographical particularities of it. And there are other factors which can be taken into account, and there is no limit for that. Here you see different elements of those factors. In conclusion, it's well established that equitable principles are at the very center of the maritime boundary delimitation. In the meantime, no method of delimitation is prescribed or enforced by law, and only prime concern will be achieving an equitable settlement. Although Article 15 of ANCORS attaches importance to the median line to be drawn by equidistance method, it also sets condition that exemptions for cases where special circumstances and historical titles exist between opposite or adjacent states whose territorial boundaries overlap. Last but not least, an alternative provisional solution also considered, and you are going to hear about this after my presentation. This is joint development management areas. This will be utilization for the hydrocarbon or fisheries resources, where maritime areas distributed are more complex by geography. This is also a doable solution, as laid out in the subpara 3 of Article 74 and 83 of ANCORS, which says provisional arrangement of practical nature could be considered and implemented in between. Last settlement reached between Israel and Lebanon in Eastern Mediterranean on 10th of October 2022 on lateral maritime delimitation seems to be the latest one employing joint development principles on hydrocarbon deposits area of Hana, which is a quasi-alike to other 20 areas where joint development provision recognized at large. Ladies and gentlemen, this concludes my time and torturing you. Thank you for listening.
Thank you, I'm sorry that I've had to cut you short. I know you had a lot of things to say, but you're running out of time. But thank you very much. Now, before I call the next speaker, I've just had internal communication that there will be a family photo and gift presentations at 2 p.m. in front of just outside here. So could you please all make effort to be there at 2 p.m. for a family photo? That is if you want to appear in the photo, of course. I will not miss it myself. Okay, let me move on to the next speaker. And the next speaker is, are you done? Yes. Yeah. The next speaker is Dr. Leonard Barnard. Dr. Barnard has got a very long bio, but I have agreed with him that we'll make it short. He has agreed that I will only mention that he is from the Australian National Centre for Ocean Resources and Security, ANCORS, at the University of Wollongong in Australia. Dr. Barnard.
Thank you very much, Mr. Chair. I want to echo my predecessor in thanking the organizer and sponsors of the events for having me here. Also, I want to thank the interpreter team for doing a fantastic job, and I promise I'll do my best not to speak too fast during my presentation. Today, I'm going to talk about islands. We've heard in the first presentation that islands is one of the factors that could be considered, and islands tend to be a flashpoint in a lot of maritime boundary negotiation and disputes. So I'm going to talk about why is that the case. Now, there's only one article in the Law of the Sea Convention that talks about island, and that is Article 121. Now, paragraph 1 is relatively non-controversial. That's the definition of an island. Naturally formed, surrounded by water, above water at high tide. It's pretty clear, right? So if a feature in the ocean fulfills this requirement, then according to the second paragraph, they are entitled to a full extent of maritime zones. this is a graphic of low tide, mean sea level, a low tide, and then high tide. So that feature in the middle is an island. And while there are other features like low tide elevation and subsurface feature, which are not island, and we're not going to talk about it in this talk. We're just going to concern about islands, that is above water at high tide. So like I mentioned, if you fulfill the definition of island, if a feature fulfills the definition of island, that particular feature is entitled to a full range of maritime zones. Right? So from the baseline, that feature, an island can generate territorial sea, contiguous zone, exclusive economic zone, and continental shelf beyond 100 nautical miles if they have it. And beyond that, it will be the high seas and the area, which we already talked about in the previous session. Now, island becomes a flashpoint in a lot of maritime delimitation dispute because of the capability of generating a huge amount of space for resources, for EEZ and continental shelf. A small island can generate, if they entitled to 200 nautical miles continental shelf, if they do not have any immediate neighbor, they can generate an area of 125,000 square nautical miles, more than 125,000 square nautical miles. That's huge. Right? That's why islands are important for coastal states. However, we do have paragraph 3 in Article 121. Now, paragraph 3 originates because during the negotiation, and we've heard about the common heritage of mankind and how the area is supposed to be reserved for all states. Now, the concern at the negotiation was that if all islands can generate EEZ and continental shelf, that means there are less area that is reserved for common heritage of mankind. So paragraph 3 is a compromise which creates a subsection of islands called rocks. Rocks is also fulfill the definition of island under paragraph 1. The difference for rocks is they cannot sustain human habitation or economic life of their own. So those islands who cannot sustain human habitation or economic life of their own shall have no EEZ or continental shelf, which is a big deal, right? This area that you can generate, if you have full entitlement as an island, as a rock, you only can generate 452 square nautical miles. Compare that to the 125,000. So obviously, all states, if they have an island, they want it to be a full-fledged island. Right? My island is a full-fledged island, yours is a rock. And that's the source of a lot of disputes. One of the prime examples that I like to use for this issue is Okinawa-Torishima. Now, Okinawa-Torishima is an atoll in the Pacific, and it belongs to Japan. Sovereignty is not disputed. But this atoll only has 3 rocks that are above water at high tide. So naturally formed, surrounded by water, above water at high tide, fulfill the definition of islands. Can they sustain human habitation? Would you want to live there permanently? Right? Now, Japan claimed full-fledged EEZ and even submitted information to the Commission of the Limit on the Continental Shelf, claiming that this tiny 3 rocks can generate not only EEZ, but continental shelf beyond 200 nautical miles. And Japan did all they could to protect these tiny rocks. They don't build on it, but they built a fortress around it. So that's the natural rock. As you can see, they left it in the natural state. They just built a seawall around it to make sure that it will always be above water at high tide. Right? So this is the issue now. And another complication is the fact that there are no close neighbors around Japan, or around Okinawa-Torishima. If you have close neighbors, you will have someone to challenge you. But Japan, these 3 rocks, so far from any other countries who would challenge, right? In fact, Korea and China has challenged Japan. They're sending a note to the CLCS saying that, well, look, these three rocks cannot be entitled for EU continental shelf. Now, the Commission actually frees any recommendation regarding Okinawa Torishima, but the dispute remains unresolved for the moment. Right? So, state practice basically unhelpful in determining what is a rock, what is an island. And until 2016, actually, courts and tribunals always sidestep the issue. There are a lot of opportunities in front of the ICJ or other tribunals to address this issue, to clarify this issue, but they always manage to find a way to sidestep it. Right? But we do have a rock hall precedent. This is the only time that I know of. Some of you might know other examples. But this is the most famous one where a state actually pulled back their claim. Rock hall belongs to the United Kingdom. It's a rock pinnacle. Right? And at first, the UK tried to claim that it can generate full-fledged EEZ. But after the adoption of the convention, they changed their mind and said that no, it's a rock, it's only generated 12 nautical miles, and they pulled back their claim. As you can see that on the right there, the area that it could have claimed if they claimed full EEZ, and now they put it back. And they only measure EEZ from the main islands of the United Kingdom. So this is the only example that I know of where a state actually pulled back their claim. Right? All other state practice usually insist that their island can generate EEZ and continental shelf. Now, I mentioned courts and tribunals have always sidestepped the issue. They do not want to enter this issue because they know how sensitive this is. The arbitration around the South China Sea between the Philippines and China is the first tribunal or courts that actually address this issue. I don't want to go into too much detail on this case because we have a session on this tomorrow. Right? But basically, the dispute is very complex and it's have a lot of layers. There's a sovereignty dispute and there's a maritime dispute. Right? I want to focus on the dispute around the Spratly Islands. There are a lot of island groups in the South China Sea. Now, the focus of the case between Philippines and China is around the group of islands, what we call the Spratlys. A group of small islands. And the sovereignty of these islands are disputed between China, Philippines, and Vietnam, actually. Now, in this case, Philippines did not ask the tribunal to determine who owns the island, right? But these islands are located within the 200 nautical miles of Philippines mainland. So basically, it's located in Philippines EEZ, all this group of islands, right? So Philippines went to the tribunal and argued that these islands, no matter who owns them, can only generate 12 nautical miles territorial sea. It is not, they are not full-fledged islands. Right? So that's one of the main questions that the tribunal has to consider is, can these islands generate EEZ and continental shelf? Basically, whether they are rocks or islands. Now, this is the largest island in the Spratly, Ituaba. It is occupied by Taiwan. Right? 46 hectares. They have a runway more than 1 kilometer long. Population around 600 personnel, but they're not permanent community. It's seasonal, sent by the Taiwan government. Right? They have power station. They claim to have 4 freshwater well. So there are some capability at least to have some vegetation. Right? And that's the aerial view of Ituaba, and you can see the long runway there, and there's the new harbor that they built in 2015. But the courts basically, the tribunal, considered it, not just Ituaba, but the whole islands of the Spratlys, whether they are rocks that, or island, whether they can sustain human habitation or not. Now, the tribunal found that To fulfill this requirement, human presence must be sustained for a time period at a sufficient standard. So it's not just seasonal, right? And habitation requires a community. They stay and settle permanently, or have the intention to stay permanently, right? Economic activity has to be local and not just about extraction. It has to support the economy of the community. Right? And based on this consideration, the tribunal finds that none of the islands in the strategy can generate EEZ or continental shelf, effectively saying that all the islands in the strategies are rocks. They can only generate 12 nautical miles. This is a win for the Philippines because then no matter who owns the island, at least in the Philippines' view, these islands can only generate 12 nautical miles. Right? So this is the only instance where a tribunal actually addressed and tried to clarify the definition of rock and island. Right? Whether or not this precedent will stick, we don't know. Right? Because the case is only applied to Philippines and China, only binding to Philippines and China. However, again, it's the only judgment on rock and islands, so it has some influence, not just on future cases, but on how states negotiate boundary whenever there's island around that they have to deal with. Right? So I am aware I will have 3 minutes left, so I'm just going to quickly address the issue of artificial islands. Right? Basically, can you build your island? Answer is yes, but you have to build it in your own maritime zones, EEZ or continental shelf. Now, such artificial islands does not have the same status of island, because remember, the definition of islands has to be naturally formed. So basically, these artificial islands do not possess the status of an island, so they do not get any maritime zones, not even territorial sea. They could establish a safety zone for 500 meters around it for safety of navigation purposes. But that is not a maritime zone. It is not a territorial sea. It is not completely zoned, not in the, obviously not the EEZ or continental shelf. Now, there are differences between artificial island building and reclamation. Reclamation means you're enforcing your coast or you're adding to your coast. And this has been the practice. Netherlands has done it, Singapore has done it. It pushes the normal baseline seawards, right? This is an example of how Singapore has done reclamation. But Singapore done it on their natural land and coastline. So this is different from artificial islands, right? Because it's still naturally formed. They just extended the coastline. And in this case, the effective delimitation is not expressly stated in the convention, although in the negotiation of boundary between Singapore and Indonesia, Singapore agreed to use the baseline of the original coast, not based on the land that they reclaimed. And again, I would just want to point out the difference between artificial island building or when you create artificial islands, or when you build a feature from one thing to another. In this case, Mischief Reef in the South China Sea, it's a low tide elevation. But China has built it, as you can see, that it becomes more than just a low tide elevation. It becomes permanently above water. Right? Now, again, I want to make reference to the South China Sea case where the tribunal said, in that case, that island building is unlawful because in its natural state, Mischief is a low tide elevation. So even though you build a low tide elevation, it does not change the natural status of that feature. Right? So you can build a low tide elevation, but it doesn't make it an island. Right? So that is the last of my presentation. That's 15 minutes according to my stopwatch. I'm happy to have any questions and discussion after this. Thank you very much.
Thank you, Bernard. That was a very good presentation, and I'm happy you kept the time. And my third speaker is going to be Professor Karan. Professor Karan He's a colleague at work and a friend, and it's a person that I've known for longer than most other people. Again, like all the rest of us, he's got a very long bio. But for the moment, I will just, we were agreeing with him that I'll just mention a few of them. Professor Karan holds a PhD from London Metropolitan University. He is the chair of the Board of Governors of the UCAM, and he is an advisor to the Ministry of Foreign Affairs. He is the delegate to the legal committee of the IMO, and he also represents the the Turkish Chamber of Commerce at the International Chamber of Commerce meeting. So he's published quite a lot. I think that's more than enough. So, Professor Karan.
Let's say, good noon. I'm really honored to be here to present a paper in front of my supervisor, Düzeydeki. I'm really pleased with this, and having presentation under his moderation, but at the same time I'm really honored because we have three researchers who have already presented their papers reading for PhD under my supervision. So he's my PhD father, and let's say our PhD students, PhD candidates. It's good to be here. So I will start to speak on the obligations on the state parties or the countries relating to Article 74 and 83 of the United Nations Convention on the Law of the Sea. The peace at sea has been in danger or threatened because of the unilateral actions in the disputed areas in breach of the certain obligations under the ANCORS, which requires every state to make every effort to cooperate with others to achieve equitable solutions in good faith through agreements, if not through court decisions. If not, avoid actions that may prevent the realization of the final delimitation agreement and reach interim arrangements until the final delimitation agreement is reached. Coming to maritime areas in boundary dispute. In maritime areas where sovereign claims have spread to wider areas just because of the adoption of the ANCORS in 1982. The emergence of important disputes has become inevitable. Today, there are approximately 400 maritime delimitation disputes, especially after the second half of the 20th century, including the ones relating to the agency and the Eastern Mediterranean Sea. Maritime delimitation disputes arise especially between the states with opposite or adjacent coasts because of the insufficient size of the sea for the coastal states to exercise full maritime jurisdiction there, or the variability of geographical conditions and structures, the presence of islands and other special circumstances, especially which exist particularly in the enclosed or semi-enclosed seas, like the agency or the Eastern Mediterranean Sea. Coming to the agency, there are so many disputes between Turkey and Greece, starting from the scope of the dispute, law applicable to the dispute, the delimitation of maritime and aviation areas, the means to be used for the settlement of the disputes, the meaning of equitable solution, the length of the territorial waters, the meaning and the role of islands in their entitlements to or in the delimitation of the maritime sovereign right zones or jurisdiction zones, the title of the islands, and the unlawful unmilitarization of the islands. In comparison to the one relating to the Eastern Mediterranean Sea, there is just one issue, which is the delimitation of the continental shelves and exclusive economic zones right now. Coming to the source of international, because it's very important to analyze the disputes under the umbrella of law, but we need to understand which law applicable in this context. Article 38 of the Statute of the International Court of Justice clearly states that the international conventions to which the related state is a party. The second, let's say, international customs to which the related state has no objection, clear and persistent objection. And three is the general principles of law. There are three sources. Coming to the ANCORS, this is an international convention, and it's very important. It's a fundamental source of international law of the sea. Nobody argues that. Sometimes it can be referred as a constitution of the law of the sea. But coming to Turkey, Turkey is not a party to that convention at all. So it has some reservations, objections, they've been carried out from the beginning of the adoption of the rules in the Law of the Sea Convention, the ANCORS. But Turkey based its objections just on the 3 articles out of 217 articles. The one article is 3 on the extension of the territorial waters to 12 nautical miles. The second, Article 33, on the contiguous zone, which poses a new delimitation obstacle. And number 3, Article 121, on the definition of the islands and their entitlement to maritime jurisdiction areas in such a way as to unjustifiably extend the scope of the jurisdiction of the mainland states due to their islands. But the main obstacle behind the adoption or the acceptance of the ANCORS for Turkey is not these 3 articles. It's the Article 309 of the ANCORS, which prohibits Turkey to bring reservation to the ANCORS. I can understand that this was the reason for having the unification in a broader sense. It's acceptable. But let me say that when I look at the provisions of the ANCORS, it was written for the unification of not individual seas requiring special attention, but especially for oceans. Nothing to do with the semi-enclosed seas or enclosed seas. There is just one provision requiring, I'm going to talk about that, requiring cooperation or collaboration. But indeed, we are talking about the unification for the oceans, ocean states. Let's see. Coming to the obligations under the ANCORS, I must say that, firstly, these provisions in Articles 74 and 83 of the ANCORS, Turkey has no objections at all to that. In the beginning, it was thought that we are in favor of the equitable solution, as referred in these articles. We have no problem with this. So, this is the law acceptable, needs to be acceptable for all states, including Turkey. And the first obligation is to cooperate and collaborate in good faith to reach equitable solutions through agreements, and if not, through court decisions. And Article 38 of the International Court of Justice Statute clearly refers to the general principles of law, which includes, of course, good faith. We need to act in good faith, especially to settle our problems together. And in good faith, the conduct in good faith requires the cooperation and collaboration as stated in the North Sea Continental Shelf case. And again, we can find a source in Article 1 of the United Nations Convention, United Nations Charter 1945, Article 123 of the ANCORS, especially for the semi-enclosed or enclosed seas, and especially those two articles in the ANCORS 74 and 83. The scope of the obligation is very clear: to make every effort in good faith to collaborate to reach an equitable solution through agreements, if not through court decisions for the settlement of their disputes. And the Security Council resolution in 1976 called upon Turkey and Greece to resume direct negotiations over their differences and appealed them to do everything within their power to ensure that these negotiations result in mutually acceptable solutions. By now, we have not reached any consensus. But there is a ban agreement signed in the same year, in 1976, requiring negotiations between Turkey and Greece with a view to reaching an agreement on the delimitation of continental shelf. But bilateral talks started from 2002 to 2021 with 63 rounds in vain. We didn't gain anything right now because of the political situations in both countries. The Turkish president invited several times the Greek partner to come and to see and to discuss the issues, but it has never been received any answer. I understand that it's quite difficult to come into a consensus on the sovereign issues, which are very sensitive because of the high public tension in the states. So there must be some other methods needs to be followed under the international law of the sea, or the international law. Coming to the next stage, next obligation, the states are obliged not to hamper or jeopardize the reaching of the final agreement. Recognition of the exploration and exploitation of resources in the maritime areas of the coastal states as their sovereign rights and expectations from other states to respect those are the ones, very important issue right now. Everybody would like to, every state would like to be entitled to the rights in their jurisdiction, and they expect the respect from other states. But what about the areas in dispute? So it's quite difficult to expect that kind of respect from the other side. Article 18 of the Vienna Convention on the Law of Treaties, the Asian case judgment in 1978, together with Articles 74 and 83, they all refers to the obligation not to jeopardize or hamper the reaching of the final agreement. But the scope of the obligation covers actions that would cause irreversible permanent damage to the seabed, such as the exploitation of oil and gas reserves. What about the seismic works? Considering the judgment in Guyana Suriname case, no. You can do that. But coming to the case between Turkey and Greece, you cannot do under the Berlin Agreement. They're all postponed from that agreement. There are so many unfortunate bilateral or especially military actions in the region of especially Eastern Mediterranean Sea. And I'm not going to talk about those because it's going to be presented in the next session. So I'll be skipping these actions from some related countries. But he was my supervisor, yeah, so I don't know.
Chairman's ambush.
Okay. I don't want to see. Okay, anyway. To make every effort to enter provisional arrangements of a practical nature. This was the one coming from the case in 1969, North Case Continental Shelf case. So there is an obligation on this, on the countries, on the states. And it was repeated in different decisions. The purpose of the provision to enable states to utilize resources in the disputed areas and to develop cooperation either temporarily or permanently to achieve joint development or joint management. Joint development mechanism granting the relevant states the opportunity to benefit from the natural resources in the disputed areas. But joint management mechanism granting the relevant states the more opportunity to manage, conserve, explore, and exploit the resources together with the protection of marine environment and securing the maritime safety and security. Instead of disputing on the sovereign issues like the delimitation, need for encouraging the states to sit on the table to start developing or managing the area in dispute today. Without the exploration of the disputed area, none of the states may decide on the final distribution. So why not explore the area together? Again, maritime areas needs to be protected for the environmental reasons and needs to be secured for the navigational or other reasons. Let's do it together. Why not? The economic resources may have some meaning today, yes, but may not be the same value tomorrow. Think about the coal. It was the energy resources of yesterday, but not today. And there are some new energy resources is going to be in hand. If you find the oil gas in after 20 years or 50 years, what is the value of that? So we need to take these resources in our hands jointly and then decide who is going to get what's the proportion for each state. Turkey's proposal for the joint development or the joint management of the area has not been really taken into consideration by other relevant states. This is all I would like to say. Thank you very much for your patience, and I'm ready for answering your questions.
Thank you very much, Professor Karan. I'm sorry I was hard to harass you, but I think we are close out of time. My next speaker is from Spain, but I have been told that in Spanish culture, I've got to mention all her names. Okay, so my next speaker is Professor Dr. Carmen Farah Rodriguez.
Very good.
Professor Rodriguez is from the University of Barcelona. She graduated from the University of Granada and holds a PhD of the University of Barcelona. She holds about 3 directorates at the university. And she's a professor of international law and European law. She also advises the ministries. She holds 2 advisory positions to the ministries of, I think, Catalonian state. The floor is yours.
Thank you very much. And thank you on the organization to invite me to make this presentation to distinguished audience. Well, the title of my presentation is very ambitious. I have a summary, but I think that to develop this is like the challenge to put all the sum of this speech in this bottle. Impossible, but I will try. First I want to speak about the concept of peace. Peace is a state of well-being, stability, and security, which is opposite to war and has a positive connotation. And I have image about the negative peace that we have now, the problem with the grain supply in with the African countries for the blocking of the Black Sea. We have the problem with immigration that we saw yesterday, the death of a lot of people for the sea, and also the traditional situation with warships trying to control different territories. But I don't want to be negative, and I want to be positive. And I want to develop here the positive conception of peace. Because peace is to enjoy the work, the healthy, the education, all the freedom that the peace can to give us the possibility to have a quality of life. And this situation we can find inside the sea. And it's this conception that I want to develop in my presentation. To have this conception, positive conception of peace, I have a maritime, eliminate the maritime dispute inside the areas of the sea. In this case, I only go to abstract the brilliant presentation of my colleague, Dr. Deniz Hukukundaki and Dr. Karam, and I go only to show the peaceful area that I go to apply joint management and development of the sea. In my positive vision of the positive peace, I say that the coastal state maritime claims and ordering are not very higher, because between 1970 to 2022, only we have more or less 1,160 cases, because the most cases have been resolved without the need to file a lawsuit in court, because have been the result of international negotiation or through a conciliation or through agreement with the state. The most important that my colleagues have explained are in the continental shelf, exclusive economic zone, island, and state baseline. But in all the cases are political limits, because in the sea don't exist physical limits, because don't exist a physical boundary, and we need to analyze the situation to try to find a peaceful area. I got a different group of states, state with the opposite coast, adjacent coast state, with the dispute, with the legal solution that they are explaining, the Kurdistan principle, equitable principle, with a specific circumstance taking account in each case. It's very important to have a solution to use the flexibility and fairness of the rule of special circumstance, like geographical aspect, historical circumstance, but not the economic difference, because the court reject this method because they consider that it's not effective or dependent on a specific moment in the history. We have legal instruments by convention, a lot of bilateral convention, because it's very easy to have an agreement between two states. But we have an important convention in the United Nations Convention Law of the Sea, that we have a solution for the delimitation of maritime areas, and we have the possibility to have settlement dispute about jurisdictional and non-jurisdictional solution. But also we have other instruments in international customary with the general practice and opinion juris and general principle that I make is here and abstract in equitable proportionality amputation. Land dominates the sea and not overlapping in the different cases in front of the court. We have the most important international court in the International Court of Justice and in the International Tribunal for the Law of the Sea, that the IMO, that I show the last judgment in this area. But all these situations that I explained only to arrive at the center of my presentation is in relationship with the joint management and development in the area of the sea. But we have, or I will develop two subjects. One is the economic impact and the other the resources in the sea. Well, I want to say that I want a positive vision of this joint management and development, because it's true that we have a lot of problems that in other presentations my colleagues are explained, but we need to see also the good practice that we have in this area, because it's true that immigration, exploitation is now, but we need to show the good things that we do in these areas. I explain, for example, the fisheries, and I present the last judgment in the Court of Justice of the European Union that show how the court has annulled agreement between Morocco and the European Union, because the court considered that they don't give the benefits the community, the autonomous community in the area of the Sahara. And we can see that start and change in the point of view that we need to collaborate and to invest in the population that are in these developing countries or in areas with no good economic situation. On the other hand, we have legal instruments, and we go again to the European Union, and we have a regulation from 2016 that they establish a specific condition for fishing for deep sea stock in the northeast Atlantic to try to stop the fishing in this area to avoid the extinction of the species. And I have also the possibility to create in the private action a joint venture with companies that are binding to apply or to invest in infrastructure in the area of the fish, and the other side to training the crew of the autonomous population in this area. On the other hand, we have the commercial lines, and we need to support and to try that this important line of communication for the economy and for the life of the people was effective in this development of this joint management. On the other hand, we have the natural resources, and my colleague in the panel before, they have explained brilliantly all the possibility that we we have in the sea. The energy sources now are especially for hydrocarbon, but we have the possibility to change for renewable energy and to have other possibility in the continental shelf, in the exclusive economic zone. And the same for mineral exploitation, and specifically in the future for the rare mineral that will be very necessary for the technological aspect in the economy. And for the other hand, we have the conservation of marine environment, and we have MARPOL with important international convention, for example, the Convention for the Prevention of Pollution from Ships. In this case, I share with my colleague, the Professor Proyes, the fragmentation of the international law, in this case, to preserve the marine environment. And we have, I put an example of the work under private companies. Is the case of a Spanish company, ECOAL, that is working to clean the ocean in the west, producing shoes and teachers with all the waste that they are in the ocean. What's the challenge? The challenge is don't keep making mistakes. We will try to use to make a rational use of the polymetallic nodules and the rare metal that are in the sea. On the other hand, change the paradigm. We have other commercial lines, like the Arctic commercial line, and we need to avoid pollution, to avoid the war between the companies to use this area. On the other hand, we need to reduce the waste in the ocean, and it's very important, the education for this challenge, and to help in the immigration. Probably we cannot eliminate the migration in next year, but we need to put a state to eliminate difference that produce the big migration by the sea. This is open, it's very difficult to eliminate or to avoid that people arrive by the sea. Finally, I have solutions or proposals. Blue economy, very important. My colleague had to speak about all the things that we can get with the blue economy. For me, it's very important regional policies, multilateralism. We need to use this tool for the future, and awareness and education. Good practice is spreading next generation to the sake of peace of sea. Thank you very much.
Okay, thank you very much, Professor Rodriguez. I now have my last but not least speaker, Dr. Professor Shaluf Hadi from Libya. I'll call him Ali. He holds a lot of positions and he has a lot of experiences. He's a professor of law at the university in Libya, and is the dean and president of the Center for Strategic and International Studies. He has also held different positions in law at the University of Kuwait, the University of Sarajevo, and two positions at the universities in South Korea. He was appointed by the International Court of International Criminal Court on a case in Darfur, in Sudan, and he has been a former member of the International Criminal Court.
Thank you, Mr. Chair. It's a great honor to be with you today, and then I would like to express all my gratitude and thankful to all of you and then to organizers. Of course, before we are talking about the convention was signed and then also ratified by the Turkish government, we have to get some idea about the situation in Libya. Some from you maybe don't know how is the situation actually in Libya, and then especially after 42 years government by Gaddafi regime, where that Libya has no any contact or any good relation with other countries or neighbors. For that in 2011, where that Gaddafi regime was shut down, and then we were blasted by the revolutionists, and then also we was elected the new parliament, and then also we come back again to have another parliament, which was 2014. But this is divided Libyan authority. We have two authorities, one in the east of Libya and then one of the west of Libya. The east of the Libya was governed by the military, that was called General Haftar. And then the west was governed by the militia, and at the same time it was governed by the government that's created by the International Convention of Seferat. It's in Morocco, where this is government is coming, and then this is government they're asking the Turkey help. We will be talking about this. If we see the map, we will be just looking at Libya, it's far away from Ankara, from Istanbul, and then we could be flying from Tripoli or from Benghazi to London, more short time than if we go to Ankara or Istanbul or go to Madrid or others that we have just 2 hours, 2.5 or 3 hours. Anyway, that we have a history also. We will be not forget that Libya was one member of the Ottoman Empire, and then it was governed by the Ottoman Empire until 2011, where the Italian they come under by Libya. In 1945, that Libya was liberated, and then this is the sea, or this is time we're talking. This is conference about how it's important today, and then we see how the resources. If we looking for the book that it was written by Major General, it's called Jihad Yahiz. He said that Libya took its neighbor from the sea. He not say that of the sea, but from the sea, where that this is definition is very difficult in international law to define if that we are member in neighbors of the sea or from the sea. This is the change in everything in the world about that. But let us see what is important for the Turkey. If we see today that Mediterranean region was all the time, all the history, it's very important because it was the place where all the civilization, all the cultures, all the religions that it was in the Mediterranean Sea. We changed it at Carthage and then we Greece, Roman Empire, Roman Holy Empire, and then Islamic Ottoman Empire. This is all, this is conflict where that we have it in the history. If we see today, there's Mediterranean after the Second World War, then it was, everyone from you, then it was very important for the war, but also today there is more warships than the Second World War in the Mediterranean. All the countries, even Japan, even South Korea, they are coming and then they are looking to have some resources from Mediterranean area. If we see that there are 100 warships in the Mediterranean, which currently witnessing that the largest gathering of the worship since the Second World War. Politically, economic, social, cultural, military, technological change, and then also continuing rapid peace in the world, and has suffered from the pain and the new order after the Cold War. At the beginning of the 20th century, the Eastern Mediterranean high carbon reserves were discovered. In fact, nobody could have predicted 25 years ago that it was, today it's estimated the natural gas reserve amount to $3 trillion US. And it's able to meet Turkey's need for about, who's imagined that? How many years? Nobody would be saying that if they say that a number. 572 years that it will be, it will be given to the Turkey, the natural gas, and that for all European Union, and then even Eastern Europe, that they would be have included UK, that they would be have 30 years, that they would be, this is estimated today. However, Turkey, they are looking to have part from this sources. This is very normal, and then they look into that. As that you know, that Turkey not signatory to the 1982 United Nations Convention regulating the maritime boundary, and does not recognize Southern Republic of Cyprus, and this agreement is economic zone struck with Egypt, Lebanon, and Israel. Turkey says it's operating in the water on its own continental shelf, on area where the self-declared Turkish Republic of Northern Cyprus. Okay, now we are coming to see that the government that is created in Sukhayrat, that is called, this is government JNA. This is the government of national accord, where that is governed by someone is called Sarraj. This is Sarraj. He come to Turkey, and then he met with President Erdogan, and then they concluded the first convention, firstly asking to help for the military camps, where now Turkey they established two bases, one in Maytiga, another one in the west of Libya. It's called Wilkia, where every day, if you see, there's many airplanes, military airplanes that you go from Turkey to Libya, and then there's more estimated. There's nobody have statistics, and then there's no any real study, but there's more than 10,000 Turkish soldiers. They are living in Tripoli and in Wilkia, and then there's many military equipment and airplanes. Okay, this is the Maritime Boundary Treaty, or the established the exclusive economic zone in the Mediterranean Sea, which means that they could claim right to share resources according to the list of maritime boundary treaties. This was the first agreement ever to be signed between two countries. However, there were expressed that the agreement may fall an energy showdown in the region because there was high continent. And then also it's very contentious about other countries, and then this is where we see there's 3 points very important, that we have a convention, but we have third party, and then we have third party, that's mean we go to another, how that we go to second, yes. We see that we have Egypt, yeah. Thank you. Okay, we have here that this is the boundary that is made by the island, where the Turkey border, and then this is where the zone was between that it will be started between Palestine and Turkey. And then the other was started by Egypt, and then could be go to Greece. Egypt and Greece and Israel, they are protesting this convention, and then we will see the Libya it was benefiting of this convention. If we come back to the first, then we will see that Libya has gained by the other conventions 39,000 kilometers that it gained by the convention. For that, for the Libyan, it's very benefit that we have this convention with Turkey, because it will give the Libyan territory more than 30,000 kilometers, more than it was before. It was this is that 63,000 that it was limited in the convention is made by 1982, but it was not a just speech, it was not really convention between Greece and Libya. But we see there, now we have one convention where delimitation the maritime border between Turkey and Libya. At the same time that we have another convention where it was just signed now between Turkey and Libya. It was about how that we will be working together between the countries. It was signed 3 October, just a few months ago, 1 month ago, where that it will be allowed to Turkey, they will become, and then they will be exploration all of the sources, especially about the gas, where that they say to you that it will be given to Turkey the opportunity, or give to Turkey great economy, especially in the gas, where that is estimated that it will be given to Turkey more than 572 years. This is very, very big number, because this area is very, very important, and then it's very, there is a lot of. Then we see now this is agreement signed meeting between Turkish President Tayyip Erdogan. This is the first one, and then with Fayyad Sarraj, head of the tribal government. This is mean. What does mean that? This is mean protecting Turkey the right to drive from the international law. Turkish foreign minister said of the memorandum of the understanding of the delimitation of the maritime jurisdiction, where that he declared that it's very important for the Turkey that we will be giving this, and then we would be trying to use it given the force. On the other side, we have the Libyan parliament in the east of the Libya, and then we have also the military where they are governed by Haftar, where that this is, they are backed by Russia, and then by France, and then by the United Emirates and Saudi Arabia and Qatar. This is country where they are using this. Okay, this is for that the government of Libya, they refusing this agreement, because the parliament is fine in the east, because some people they would be not understanding how the parliament they would be separated from the government. Normally, it's something that's very strange in Libya, where that we have two governments, and then at the same time we have the parliament. The parliament is under the military, where they would be decided what after he would be thinking. For that Libyan government, the west of the Libya, the Sarraj, they give it to the United Nations. This is a convention where that is registered. Greece and the European Union, they contested this, and then in the end, that the General Secretary of the United Nations, he said that it's not a matter of the ratified or not, that it's a matter of that registration. This is the obligation of the Charter of the United Nations, and then the 12th register. This is convention. There is no any, if someone would be asking if there is any real contestation from the Greece or from the European Union, I would say until today there is no any contestation, because there is no any contestation to the United Nations or to the any courts for that they don't went to the Maritime Court, or then went to any other jurisdiction to asking if this is treaty valuable or not. We see that in the end, I don't like to, because they give me just couple of minutes, then I would be have the house the preliminary energy exploration date. This is the last one, and that was signed just now, and this is to give the Turkey now the possibility, and then they started. They already Turkish companies they went to start working, and then without to make any decision for the contestation made by Egypt or Israel or Greece or even the European Union. The European Union, in the last convention, they say that we have no any real information about that. And then I think the fact that Turkey, they are profiting this situation, and they understand that, especially in the situation now, that Ukrainian war and all other situation, for that as also Turkey is made part from NATO. That is a comfortable way where they will be going to work. Same time, the Libyan government now, which will become stable, at least in the west of Libya, and then finally we have between the national, the petroleum company, Libya, they will be working with Turkish, and then they will be going to we see that the European Union say that details of the new agreement are not known yet, and then will not make statement. For that, this is the 12th last declarations made by the European Union. They say that we cannot say anything because we have no any information about it. This is except and other one, the agreement where that they make the delimitation of the maritime border, and then I think this is the frontier that it will be already established, so that there is no one will be saved. For personally, I am very favorable by this agreement because this will be give the Libyan more territory, and then they will be sharing with the Turkey the resources, and then it will be benefit as the foreign minister of Turkey and the Libyan. They say that it will be when all of the house, and then this is, I think, it's very, very great, and then it's a good agreement at now, and then we hope that it will be one day that the Libyan Parliament will be ratified this agreement. Thank you very much for your attention.
Thank you, Professor Hardy. I must thank my speakers for very valuable contributions. This is a very important topic, and it's a pity that we didn't have much time to discuss, especially this last one about the newest agreement between Turkey and Libya. Despite exercising strict measures, it's not impossible to keep time, but we will allow 2 questions. Look, we have a choice to either miss our lunch okay, I will. There's another alternative. We can have questions before the next session, or we have lunch, or I can take 2 burning questions, real burning questions. Okay, I will take 1 burning question from there, followed by 1 burning question from here. And maybe I should have a lady, because I think, yeah, then I will have 1 lady. So please keep it brief. Don't make a speech. Ask the question. Okay. Can you give him the microphone, please? Do you have a loud voice? Can you speak without?
Thank you very much. I'd like to thank all the panelists for their wonderful speech. My name is Ahmed Alta. I got Master in Law from London Metropolitan University. I'd like to address Professor Karen for his speech. My understanding that is Turkey 163 sessions actually of negotiation with Greece, but all of them were unfruitful. Everyone who looked at what happened at World War II and most of the islands were given to Greece can tell for any rational person that it was unfair. I'm not sure if there's any international court where Turkey can go to complain, because unfortunately I wouldn't think that is Europe or USA would stand with Turkey to ask for their rights. And I'm wondering if there's anything similar to the International Criminal Court. Even Turkey, actually, they are not a significant number of UNCLOS, but that's my question to Professor Karen. And thank you so much for allowing me for putting this question about how Turkey will aim actually to get their rights about these islands. Thank you.
Thank you very much for your question. I mean, the first thing, if you'd like to refer your dispute to the court, first you need an agreement between both countries. The first, it's quite difficult to reach at the moment to refer our dispute to court because of the high public tension between these two states right now. This is the first answer. The second, there is a reservation of Greece under the ANCORS not to refer any dispute relating to the maritime jurisdiction areas. So this is the second obstacle behind that one. The third, if you like to agree on referring the dispute, we need to first agree on the applicable law. The first. We are not really agree. Greece believes that the only law is the ANCORS 1982, but we are the persistent objector of the ANCORS. So before the agreement on the applicable law, it's quite difficult to go to the court. So again, the scope of the dispute is disputable. Greece believes that there is just one dispute between Turkey and Greece is the limitation of continental shelf. This is why this is the fact because if the Greece believe that the territorial waters is going to be extended to 12 nautical miles, then there is going to be no dispute relating to the delimitation of continental shelf. There is going to be no continental shelf at all. So this is why Turkey would like to be sure about all the disputes in the agenda, in the basket, are going to be settled by the court under the law of the sea, which is going to be the law of the sea acceptable before the adoption of 1982. Which is the customary international law relating to extension of the territorial waters. The second is the meaning of and the effect of the islands in the area, the second. And we'd like to ensure that Article 74 and 83 is going to be applicable for all the disputes. Thank you very much.
Okay, the gentleman here.
Thank you very much. I'm Professor Semishitsa, Special Advisor of the Turkish Hukuk Kurultayı President on International Diplomacy. Thank you for this entertaining panel. I would like to ask you each question each, but I know that I can. But I would like to ask two brief questions, please. One of them is Professor Hadi. It's very evident that, from the Turkey-Libyan agreement, the Libyan people will benefit most. As you mentioned, 30,000 kilometers square plus many things. So I just really wonder how the General Haftar governments can justify, his claims by rejecting this agreement. This really, and how you can explain this to his own people, because it's hard to accept this fact. That's my question. And Dr. Bernard, you talk about the rocks, and it's flashed my, memories back to 2009. When Greece used a rock which is most of the time under the water. It's called parketa rocks. And they even convinced the Albanian prime minister of that time to sign an agreement where it formed a baseline of Greece-Albanian delimitation agreement. Thanks God it come back from the Albanian court of the Supreme Court. So I just want to hear about your evaluation. How Greece can use, all these islands for its maximalist, attitudes and policies, and why you think European Union is so silent on this? Why they are thinking they're talking about that?
Okay. Professor Khan, can you answer the question? Very brief.
It was Professor.
I beg your pardon. Yeah, sorry.
Okay, as that you know that Haftar, he is backed by Emirate and Wagner, Russian and also French, and at the same time that French, that they backed the Greece, and then already they sent it in, for example, a lot of airplanes, ships. At that time we had some tension between Turkey and Greece. This is the question where that they say that it's very complicated, where that we would be not understanding how the Libyan government is not accepting to ratify the conventions concluded with Turkey, and then at the same time they give the Turkey to Greece. This is very strange, of course. I'm agreeing with you, and this is also I criticized in university, I criticized by the media, and even, for example, the TV. I say that it was a very big mistake that made it by the Libyan government. I am convinced that this is a very good agreement. It will be went to Turkey and Libya. At the same time that that in 1986, when the Libyan they declared that Gulf of the Sirte, that it will belong to Libya. In that time, Reagan, he sent the float, 60 float to the Mediterranean, and then he attacked Libya. And I think that the chair, he was there, and then he told me about that American, they come and attacking that. Just that it will be just less than 200 kilometers in Gulf of the Sirte. Today that we have more than 63,000 kilometers that it will be, and then we have very big area, and then this area is very rich by petroleum and gas. So that it would be very beneficial for Libya, but we cannot understand the position, as I said, after our Libyan government and Esther Libya. Thank you for your question.
Okay. We will have Professor with a donator, and then the chairman has just been advised that we should have Alexander as the last question. Okay. Can you give the microphone to the lady? Oh, sorry. Can you be brief?
I'll be brief. All right, thank you so much for the questions. I'll start with acknowledging that I'm not familiar with the Greek and Albanian boundaries, so I don't know what the reasons they use as base points. But boundary negotiation is basically based on agreement of two parties. If it's like, so they can agree on anything. They can agree on anything as a base point. So if Greece managed to convince Albania to use a rock underwater as a base point, more power to Greece, right? It's about negotiation. Having said that, there are situations where you can use low tide elevation as a base point. If that low tide elevation is located within 12 nautical miles of your mainland, then you can use it. I'm not sure whether that's the situation with Greece, but if not, then that proved like the negotiation power of Greece, because I'm not familiar with the case. Thank you.
Professor Lee?
Yes, thank you very much.
Could you just ask one question and make it brief? Thank you.
This is preventive. I remember that preventive self-defense doesn't exist in international law. Sorry. So, just a few points. The first one, thank you to all speakers. To Professor Karan, I do really appreciate the reference to the good fight principles and the international cooperation and the need to resolve the disputes under jurisdiction, international jurisdiction and applicable law. I totally agree, of course, but maybe we must return to basic principles of international law, parem parem non habet iudicium, because we have in front of us, in general terms, an international legal order, and in my idea, it's on the basis of all crises. We forgot the basic principles of international legal order at the basis after the Second World War. No state is different or superior to the other. It's a basic rule of international law. So I totally agree with you, and also I should to start from basic principles of international law. And the last point is in relation to the treaty. Or again, from a technical point of view, and maybe I related to the previous, the colleague previous asking, is the point is under international law, is Libya entitled as a state, as defined under international law, to sign an international treaty? It can be recognized as capable in international legal order to sign an international treaty, since the United Nations called the state as a failed state. That's the point, because the consequences over the execution of such a treaty with Turkey or other countries are, of course, impactful on both sides. That's the other point. And the last point, what about asking an advisory opinion to the International Court of Justice in relation to the dispute? I suggested to Professor Karan, why Turkey don't ask an advisory opinion to International Court of Justice on the applicable rules, for example? Thank you.
Can you respond?
Just the first intervention is, there is no question. The second one, we could all think about that.
Thank you. Thank you for your question, but I would like to say that, as you know, to go to an international justice court, you have to agree between two states to go to there. Otherwise, we cannot accept this court cannot accept any claim without the agreement between two parties. This is one of the conditions where that will be accepted by the International Court of Justice. Secondly, that Libya is not declared today, until today, not declared as failed state. Already.
Not declared, defined.
No, yes, this is the. No, this is the opinion of some people. They will be even the writing about that.
Not general people.
Excuse me. Can we keep it very fast? Can you avoid debates, please? Can you very quickly answer the question?
Okay, as I said to you that today Libya is not declared, and then they receive it. Already the United Nations they presented in Libya, and then there's one representative of the General Secretary of Libya, and then just now they nominated a new one. Before there was five, one from Lebanon, one from Spain, one was from Germany, and then one from second Lebanon also, and then this is the last one is from Senegal. For that, this is just a few days ago that he comes to Tripoli and then he will start working. For that, this is point of view of the international law. Libya is considered as a state, and then he will be signed for any treatment, and then there is no any problem for the treaty that it was signed by Libyan authority, and then for that, this is written whether the General Secretary accepting that it would be registered in security. The convention is concluded between Turkey and Libya. Thank you very much.
Yeah, thank you very much. Alexander?
Thank you so much. And let me first say how much I appreciate that I'm giving the word. I'm very grateful for that. A very brief disclaimer, I'm not taking the word as a representative of a member state of the European Union. As Professor Karan knows, I have argued at other occasions that I'm very much against any kind of absolute position, and that includes claims submitted by Greece. However, we have case law, and this goes to Professor, to my dear colleague from Libya. Excuse me, I forgot the name. Thank you, my apologies. We have case law that has clearly said that the article on islands is custom in its entirety. And that raises questions concerning the agreement, right? And that is because of Crete. Don't get me wrong, I'm not saying that all islands should be treated equal. I'm not at all saying that. I'm not saying that there is any kind of cut-off effect to the disadvantage of Turkey, but Crete is a very big island, and I do not think that it is possible to just ignore it in any kind of delimitation. So my question then is, what is the justification? Is it essentially that Libya and Turkey are protesting the customary validity of that article in its entirety? Because we are not talking about treaty law here, we're talking about custom. And that is my question. What about then the customary validity of the article on islands? And I think it plays a major role in the question at hand. Thanks.
Thank you. I said, you know, officer, that we know, you and me, we know that the customary law, this is the second source after the treaty, because the treaty is the first source today in international law. But the customary, the second sources, and then this is established by the Article 38 from the International Justice Court, where they make the sources of the international law that the customary is one second. If there is no treaty, of course, then there would be customary, then it would be first. But if there is a treaty, then it would be the first sources of the international. Today, Turkey has concluded treaty with Libya, and then it's up to Greece to go to the contestation before the courts, or to go to the United Nations, or which is the way that will be followed international law. But I am sure that the treaty will be the first source. Thank you. Thank you.
So, I'll say, and then we can just answer the final question. Turkey's position is very clear that the islands cannot give any rights to the exclusive economic zone and continental shelf. There was no exclusive economic zone before 1982 at all. And the continental shelf, regarding the continental shelf, there was no customary international law requiring entitling the states before 1982. There was some state practices, but they were not raising. They had not raised to the point of giving or entitling the states to the continental shelf. This is our belief. So this is why we believe that the agreement between Turkey and Libya is in accordance with the customary international law which exists before 1982, which exists still for Turkey, which is the persistent objective of the ANCORS, especially Article 121 of the ANCORS.
Just one remark, you see that when I was working in international criminal court, and then we meet with to examination the cases, and then usually we will be examining the cases about what it will be in the convention. This is, for example, we are not looking at for example, customary. We're going to the Rome statute, where that will be considered as the principal element where that we will be going to judgment. For that, even for example, in the International Court of Justice, they will be going to the Article 38 from the court statute, where that you could be see this is where that we have the sources. This is already defined by the Article 38. Of course, the customary law that become as that you know, for example, about maritime law, it was based on the customary law, about the Scotia case, about many other cases where that the Scotia case where that established it, but after it become treaty, how that we use today, using in the air and the space, and then before it was the Scotia case where that we using about how the light lift on light. I am pitching international public law and international relations so that this is subject, and then also working with the courts, international courts, this is something very important. Yes, please. Thank you very much. Anyway, we will be follow this discussion. Okay. If I am wrong, I will be saying it.
Thank you. Now, very quickly, lunch, they are serving lunch until 2. After 2, they won't be any lunch. Number 2, Ambassador Tartary is going to give a talk on the Turkish position. So he has agreed that he will take over from where we left and answer some of the questions. Now, this is a very rare thing. My arms have been twisted. The lady here is going to ask a very quick question.
Teşekkür ediyorum. Öncelikle herkese iyi günler diliyorum. Avukat Figen Şaşkın, Hukukçu Kadınlar Derneği Başkanı. Sayın Başkan'a ve sunumu yapan tüm hocalarımıza şükranlarımı arz ediyorum. Çok istifade ettim. Uzatmayacağım. Benim sorum Sayın Hadiye. Sunumu esnasında Türkiye ile Libya arasındaki bu anlaşmaya dair Avrupa Birliği'nin fikri sorulduğunda Avrupa Birliği'nin kendi sözleşmenin içeriğini görmediğini, dolayısıyla da şimdilik bu konuda herhangi bir mütalaa ya da fikir beyan edemeyeceğini söylediniz. Avrupa Birliği ülkelerinin Doğu Akdeniz'e kıyısı olmadığı dikkate alındığında zaten bu konuda bir fikir beyan etme ve self-determination hakkı olan Türkiye ve Libya'nın bir sözleşme yapmasının itirazı olabilir mi? Teşekkür ediyorum.
The only thing I'd like to mention, Greece is a member of the European Union, and Greece has a border to the Eastern Mediterranean Sea. So, yeah, that's right. Yeah. So, the point is that the European Union has no burden on the boundary issues, maritime boundary issues also.
Thank you for your question. Should be distinguished between two conventions. The first convention was signed between the President of Turkey and Prime Minister of Libya. This is one. It was the limitation of the maritime border between Libya and Turkey. The second one, it was concerning how that will be exploration. This is where that it was in Europe or the European Union. So that we say that we will be not talking about now, we didn't have no information about this item. Where that signed just 3 October in Tripoli by the Minister of Turkey and the Minister of the Defense, Minister of Foreign. They came to Tripoli and then they signed this agreement. So there is 2 agreements, one of them for the exploration, one of them the delimitation of the maritime border. This is definitely, but the first one already registered in United Nations, that all the countries they have the knowledge about this convention. And then if there's any country they are not accepted, they will go to the justice, international justice to claim this. Thank you very much for your question.
Okay, with those comments and remarks, I would like to bring this session to an end. Thank you very much.